thank you very much for that very warm welcome and introduction. And I should also begin by, as Sir Ronald Wilson would have, by acknowledging the traditional owners of the land, the Whadjuk and Noongar people, and I thank Matthew for his welcome. I'm really honoured to be here today to be asked to present the Ronald Wilson lecture, and I thank the President of the Law Society for asking me to. I'd like to especially acknowledge the work done by Dean Curtis in organising tonight's event and organising me. So he's done a terrific job, and I'm also really grateful that you've come here to listen to what I have to say, and I'm quite intimidated by all the guests that are here tonight. And I just should also acknowledge that I've got some of my, it's strange because I've got some people that taught me, Peter Hanford. I've got some people I found out, somebody I went to university with, who I was in the Amnesty group with, who's a teacher here tonight, and people that I've worked with at Murdoch, Ralph and Anna, and also several of my students I can see here. So you've all heard me before, so I should just sit down. So when I was asked to give this topic of refugees, I was asked about 8 months ago, and I gave it a very deliberate, broad topic. As you can see here, I didn't have it up here, sorry. Recent developments in the law relating to refugees and asylum seekers in Australia, because I thought it might change a little bit while I was doing it. It is perhaps unfortunately a very dynamic area of law that is often changing. Ever since I started practicing in this area, I hate to admit about 20 years ago, I've never found it to be stagnant. And in teaching the subject of refugee law to students, and Anna would relate to this, every time you teach it, they go, it's such an exciting time to be learning refugee law, there's so much happening. And it's like, well, every year they say that. Every year it changes. As the date came closer to deciding what of the myriad of changes that have occurred over the last few years, of the last 8 months, I thought about the first time that I ever met Sir Ronald Wilson, or I shouldn't say I met him, I saw him when I was a law student at the University of Western Australia. At that time he came to talk to us. He was a retired High Court judge. I'd never met a judge in person, and I thought they must surely be like the judgments he'd written, fairly dry, conservative, not like the progressive law student I was at the time. I couldn't have been more wrong. He'd come to talk about the United Nations Convention on the Rights of the Child. He was at that time the national president of the Uniting Church and was part of a group who were advocating that the Australian government should sign the Convention on the Rights of the Child. In talking about the convention, he was filled with incredible passion. He was a small person, but he would sort of almost jump out of his shoes when he was talking about children and children's rights. And at that time, people were really concerned, what would the Convention on the Rights of the Child mean? What sorts of rights would it give children like you that are here today, particularly over your parents? And people were worried about that. Sir Ronald dismissed all of those claims and said that the family is the basic unit of society, and the theme in the Convention that the best interests of the children should be protected, and whereas a society the family cannot provide the environment in which a child can reach their full potential, we need to ensure that rights of children are protected. In 1990, Australia did ratify and sign the Convention on the Rights of the Child, so I thought that was a good theme for tonight. I thought about that a lot of you here are young people, and I thought I'll focus on that. There are young people like you, aged between 13 and 18 years of age, who leave their homes. And what if that were you? What if that were you who had to leave your family, your home, in order to try to seek out safety and better your life and your future? What protections would be given to you? How would the...
Sorry.
That's okay. I need to turn the light on. How would you seek protection? What would you do? This is a photograph of a young man that I've been helping. His name is Mustafa, and he is a refugee. And I thought I'd tell you his journey and how he's left his home. He's 14 years of age, and as I said, he's a refugee. And a refugee, for those of you who don't know, you probably hear about it quite a bit on the television, is someone who has had to leave their home because they fear persecution on the basis of their race, nationality, membership of a particular social group, political opinion, or religion. Mustafa was born in Pakistan in a city called Quetta. He and his family are of Hazara ethnicity. They're Shia Muslim. He's got 4 sisters and 1 brother. His grandfather originally came to Pakistan from Afghanistan, but he said his grandfather left Afghanistan a long time ago, for him, what seemed a long time ago, probably only 20 years ago, because it was not safe for Hazara people there. According to minority rights group International, the Hazara people were once the largest Afghan ethnic group, constituting nearly 67% of the population of the state before the 19th century. More than half were massacred in 1893. Today, they only constitute approximately 9% of the Afghan population. The majority of Hazaras live in Hazarajat, which is situated in central Afghanistan in a very mountainous region. Continued persecution through the last 2 decades of war have driven many Hazaras from their traditional homes over the border to the fringes of Afghanistan and into Iran and Pakistan. So that basically shows you where Quetta is. You can see it is quite close to Afghanistan. That's a picture of Quetta at night time, I guess. Anyway, UNHCR 2012 Global Trends. The UNHCR is, again, for those of you who don't know, the United Nations agency that is committed to assisting the world's refugees. In its global report in 2012, said that more people are refugees or internally displaced than any other time since 1994. The report shows that at the end of 2012, more than 45.2 million people were displaced, compared to 42.5 million at the end of 2011. That includes 15.4 million refugees. Those are people who have left their country for one of those reasons I talked about further and have actually crossed a border. Of that number, of the world's refugee children below the age of 18, they make up 46% of all refugees. Afghanistan, last year, remained the world's top producers of refugees, a position it's held, sadly, for the last 32 years. On average, 1 out of every 4 of the world's refugees is Afghan, with 95% located in Pakistan or Iran. Pakistan continues to host more refugees than any other nation in the world at 1.6 million. So Mustafa's relatives, like many other families, left Afghanistan to avoid the persecution they faced in that country and went to Pakistan. Unfortunately, violence has followed the Hazara people into Pakistan. There have been continued sectarian attacks against them by extremist militant groups such as the Pakistani Taliban and other Sunni radical groups. While sectarian violence is a long-standing problem in Pakistan, attacks against the ordinary Hazara Shia population have increased dramatically in recent years. These attacks have included attacks by gunmen in markets, on buses, and more recently bombings. Mustafa's father was a construction worker and a bricklayer. He found it very difficult to continue working in Quetta because of the unsafety and had to move to Iran. So from the time Mustafa was very young, he went back and forth to Iran for 2 to 3 months at a time, would come back to Quetta to see his family and return again. Mustafa had a normal life. So he tells me he went to school in Quetta. He was very smart and he did very well. He speaks English extremely well. He was asked to go up a year at one stage at school. In late 2011, when he was only 12 years old, his father called him from the border of Pakistan and Iran, just after he'd had his passport checked. His dad said he was coming home. After that, his family didn't hear from him again. They suspect he was the victim of an attack on the bus he was travelling on, as there'd been previous attacks reported in months prior to his father's disappearance. To this day, he doesn't know if his father is alive or dead. Even though he was 12 years of age, Mustafa had to leave school and go to work. As the eldest boy in his family, and with his father gone, culturally it was his responsibility to care and support his family. He began to look for work. He worked making rugs near his home. He worked for many different people who needed workers. His mother and sisters also worked sewing clothes. During the time, again, attacks in Quetta continued. In January 2013, 2 suicide bombers targeted a snooker club in Quetta, killing 82 people, injuring 121 others. On 16th of February 2013, Mustafa went out to the local vegetable market He's now 14 years of age, to get food for his family. 20 minutes after he left, at almost 6 p.m. at night, a vehicle packed with over, it's reported, 800 kilograms of explosives exploded, destroying nearby buildings and killing at least 84 people and injuring almost 200 others. But basically the situation is, with the targeting of various groups in Quetta, the Pakistani government has been quite ineffective at protecting the Shia minority population. Mustafa told me he knew that extremist groups in Quetta were targeting Hazara people, and he said that their view was that Hazara must be killed or leave Quetta. And he told me, it's not safe to go out. It feels like you're a prisoner in your own house. We cannot move. I wanted to be alive. I wanted to live. Who could he go to for help? He's a Pakistani citizen. He's not a refugee in Pakistan. He can't go to the United Nations High Commissioner for Refugees. He can't go to the authorities in that country because they're not providing protection. After that narrow escape from the bomb blast on the 16th of February, he felt he had to leave Quetta. He said he felt he had no choice. He was the carer of his family and he was their future. He had to find somewhere safe for them to go. He discussed leaving with his mum, and they made the decision he had to leave. He talked to his friends and neighbours who were also talking about leaving and found a people smuggler. The smuggler asked him for $7,000 to take him from Quetta to Indonesia. Once there, it would cost him a further $5,000 to go from Indonesia to Australia. Mustafa didn't have the money to pay him, so he borrowed money from his relatives and people who knew him or his father, and he paid him $5,000 to take him to Indonesia. In late March, he left his home with no family member, no relative, and he's now just 14 years old. The reason for movement away from a country of origin are often referred to as push factors. In Mustafa's case, the push factor is obvious: the lack of security, fear of persecution. For others, it may not be so obvious. In particular, in recent times, the Foreign Minister, Senator Bob Carr, has stated that many people arriving by boat are leaving their country of origin for economic reasons and that they're in search of a better life. A distinction is made between those who have economic capacity to leave via a people smuggler and those who can't. Assumptions made that they are some way less deserving of protection. The use of pejorative labels such as economic migrants or individuals in search of a better life is problematic for a number of reasons. It depicts asylum seekers as opportunistic, privileged, and incorrectly implies asylum seekers who are middle class, have economic resources, or have the desire for improved employment prospects are exempt from having been persecuted. Just as a serious risk of violation of civil and political liberties can allow for a claim of refugee protection, so too can claims for basic socio-economic needs. In Mustafa's case, socio-economic reasons may also be at play in his decision to leave, not just the fear of persecution. He can't go to school anymore. He has to work at very difficult manual work to support his family. Opportunities for permanent residence, education, relative prosperity and access to employment may be factors that he has to weigh up in considering whether he would choose to leave and seek asylum. Those factors can commonly be called pull factors. It may also be the case that the choice of destination was determined for him by people smugglers and the relative costs of potential pathways. When I asked him why he decided to go to Australia, he said it was because Australia is the only country that accepts the innocent victims and refugees. In March 2013, he left Pakistan, went to Thailand, Malaysia, and then to Indonesia. 2 days after he arrived in Indonesia, he registered with the United Nations High Commission for Refugees. It's now April 2013. Other asylum seekers who were in Indonesia told him he would have to wait for about 9 to 10 months before the UNHCR would even interview him, let alone find him to be a refugee. In June 2013, Human Rights Watch released a report, Barely Surviving: Detention, Abuse, Neglect of Migrant Children in Indonesia. The report notes that Indonesia has seen a remarkable increase in the number of asylum seekers, going from 385 in 2008 to almost 10,000 by the end of February 2013. Of that, there are almost 1,200 unaccompanied minors. And when I mean unaccompanied minors, that's who I'm talking about here with Mustafa, a young person who's under the age of 18 and left without a guardian accompanying them. The real figures are likely to be much higher than that, as many do not identify themselves to the immigration authorities or UNHCR for fear of being arrested or detained. Human Rights Watch notes that the hazards of the onward journey to Australia for asylum seekers for unaccompanied minors in Indonesia, and states that the unaccompanied minors they interviewed for their research said that they would take that risk despite the hazards, as it was preferable to waiting in Indonesia. I'll just put up a map here. This is it's not a very clear map. It's clear on my screen, but the map, you can see it's a map of the world, and that's what we are looking at here. In green are countries that have signed and ratified the convention relating to the status of refugees. In grey are the countries that have not signed the convention relating to the status of refugees. Indonesia has not ratified the 1951 Convention relating to the status of refugees, nor its 1967 protocol. If you read those two documents together, they provide that a signatory state must not return people who are refugees to a country where they would face persecution on the basis of their nationality, race, political opinion, religion, or membership of a particular social group. Persons who are found to be refugees should be accorded certain rights while in the host state, such as the right to freedom of movement, access to education, rights to work, and social welfare. Indonesia does not have a domestic legal framework to protect refugees. The protection of refugees and asylum seekers in Indonesia are left to the UNHCR and the International Organisation for Migration. Those that are detected by immigration authorities in Indonesia who are not there lawfully will be detained. Human Rights Watch noted in its report that many children are arbitrarily detained in terrible conditions for months or even years. I was able to visit Indonesia in January this year as part of being a member of the Ministerial Council advising the Minister on asylum seekers and refugees. When we were there, we were told that there were about 200 unaccompanied minors, mostly Afghan, who were in detention in Indonesia that they knew of, 33 of whom had already been found to be refugees. They need to be found to be refugees before they can get assistance from the UNHCR. It's only at that time that they can be released into shelters in community houses. When we asked, what are those shelters like, how many are there, we were told there were 2 community houses in Jakarta run by an NGO, which was an implementing partner with the UNHCR. Those shelters had a capacity, we were advised, to house only 10 to 20 unaccompanied minors each. But they had in them 60 to 100 unaccompanied minors. Because there was no room in the shelters, those that had been found to be refugees in Indonesia could not be released. Others who do escape detention by immigration authorities are left to fend for themselves on the streets. They have no legal status or protection under Indonesian law. They cannot work and they have limited access to education. They're constantly vulnerable to arrest. Desperately worried about his situation, the prospects of waiting in Indonesia under these conditions, Mustafa decided to take a boat. He said, I didn't have $5,000 for the trip to Indonesia. I didn't have any money left. But the smuggler let me go for free because other asylum seekers in our group paid and fixed it for him so I could go for free. I've got a series of photographs here, which are quite incredible photographs from another refugee who spent some time in Indonesia, a Hazara refugee by the name of Barat Ali Batur. He is a photojournalist from Afghanistan and was fleeing Afghanistan and travelled via Indonesia. And during that trip, he documented his journey, and he gave me permission to use his photographs tonight, so I wanted to acknowledge him. So this is a photograph of people paying a people smuggler. So Mustafa was taken to a house. He was locked in there all day with some other people. In the evening they were moved, travelled for about 6 hours to an island. They were put on a boat at about 2 or 3 o'clock in the morning. There were 72 people aboard that boat. And I'll just show you some pictures of, this is a boat that, this is not Mustafa's boat, but this is a boat that Batur travelled on, which during the voyage unfortunately broke apart and sank. So these are pictures taken just before the boat actually sank, and he managed to keep the photographs. So Mustafa was on that boat, and after being at sea for 9 hours with 72 other people, the boat simply broke apart. Most people on the boat drowned. Mustafa and 13 others managed to hold on to part of the boat, and they were rescued after 24 hours in the water, thinking they were going to die, when a fishing boat went past and saved them. We can only imagine, and I don't think I could tell you, what it would be like to be in the water for 24 hours and to have watched other people around you drown. And he told me there were women and children on the boat and other unaccompanied minors. 14 people survived from that boat, the other 58 perished. The sinking of his boat was covered by ABC's Lateline, and this is a picture of Mustafa the day after he was rescued. He looks very thin in comparison to the previous pictures, and has quite bad sun damage. It was after Mustafa was rescued that I came into contact with him. His story was covered by an ABC journalist on Lateline. So 14 survived from that boat, 58 perished. At that point I came into contact with Mustafa. He managed to save his UNHCR certificate and agreed to try to help him to try to stay in Indonesia rather than get on another boat, to try to apply for refugee status with the UNHCR, and to try to get some safety and not get back on another boat. I'll leave his story at that point, and I'll come back to it later. Now, concern over boat arrivals has preoccupied much discussion by politicians, academics and the community. What are our international human rights obligations to those who come and seek protection? Australia is a signatory to the Refugees Convention and a variety of other international human rights obligations, including the Convention on the Rights of the Child. However, Australia has been traditionally reluctant to incorporate those rights into the domestic legal framework to create enforceable obligations against the government. Boat arrivals, there's no question, have been increasing over recent years. There have been peaks and troughs over a long period of time associated with particular waves of asylum seekers. During the early 2000s, the highest rate was 4,137. That was prior to the introduction of the Pacific Solution by the Howard government. After once the Pacific Solution was dismantled by the incoming Rudd Labor government, in 2005 to 2006 there were 57 arrivals. In 2009 to 2010, 5,315 arrivals, and 2011-2012, 8,092 arrivals. In 2011 to 2012, of that nearly 8,100 arrivals, were 889 arrivals were recorded as unaccompanied minors, or almost 10% of all arrivals. There's been a variety of deterrent measures around detention, different methods of processing, restricting judicial review, which are too numerous to go into tonight. But they've clearly not been successful at slowing the arrivals. So I'll start by not taking you too far back, but talking about the ill-fated Malaysia solution. Concerns about arrivals led the Gillard Labor government to enter into an agreement with the Malaysian government Funded by Australia, the agreement involved the transfer to Malaysia of 800 asylum seekers who arrive in Australia by boat. Those would be sent to Malaysia. In exchange, Australia agreed to resettle 4,000 refugees from Malaysia. It was estimated at the time, and it continues to be the case, that there are about 90,000 asylum seekers and refugees in Indonesia. Their chances of resettlement from Indonesia to another country are very slim. On the 24th of July 2011, the Minister for Immigration, Chris Bowen, issued an instrument of declaration authorising the transfer of asylum seekers to Malaysia as a declared country under Section 198A of the Migration Act. The Minister made it clear that unaccompanied minors would be included in the group to be sent to Malaysia as part of the agreement. He reasoned the inclusion of children and unaccompanied minors was necessary as a deterrent to their parents, who might otherwise be encouraged to expose their children to perilous journeys to Australia. So it's kind of the greater good argument. The announcement of the agreement met with a concerted campaign of opposition, culminating in a challenge in the High Court, brought on behalf of 2 asylum seekers slated for removal to Malaysia, one of which was a 16-year-old Afghan boy who was unaccompanied. Concerns about conditions in Malaysia for unaccompanied minors were similar to those in Indonesia. At worst, it was feared he would be subject to detention, ill treatment, exploitation. At best, he could expect to remain in Malaysia for many years with little or no prospect of resettlement to a third country. So began litigation in the case of Plaintiff M70 and Plaintiff M106 and the Minister for Immigration. So you can see the section there, section 198A, provides that an officer may take an offshore entry person. We've come up with a number of very clinical names for people who arrive by boat, but basically a person who's come by boat to Australia, to another country in respect of which a declaration has been made under subsection 3. Subsection 3A, which is up on the screen, says that the Minister must issue a declaration which sets out that the specified country, in this case Malaysia, provides access to persons seeking asylum to effective procedures for assessing their refugee status, provides protection for people seeking asylum. So how do they live every day? Are they able to work? Are they able to access housing? Are they able to access education? Provides protection to people who are eventually given refugee status pending either their return home or voluntary resettlement, and that it meets relevant human rights standards in providing protection. The Minister argued in this case that those were issues which he had covered in the agreement with Malaysia, and that it was up to the Minister to make that determination and not an issue for the courts to look at. The majority of the High Court found that the terms of section 198A constituted jurisdictional facts, such that a declaration made by the Minister would be invalid if made in respect of a country that did not meet those criteria. In this case, while they accepted the agreement and attempted to put into place certain protections for asylum seekers that would be sent pursuant to this agreement, it wouldn't alter the fact that Malaysia in fact didn't have laws which recognised and protected refugees from return to their country of origin and persecution. Also in question was the Immigration Guardianship of Children Act. This is a particular act which was established in the 1940s to deal with the arrival of young British migrants. Under the Act, the Minister for Immigration is the guardian of any young person that arrives in Australia without a guardian. Section 6A of that Act required that the Minister for Immigration has to consent in writing for the removal of any unaccompanied minor from Australia. The court found in this particular case, rather than look at, well, did he consider his role as a guardian in this case? Did he consider the interests of the child? The court narrowly decided in this particular case that looking at the agreement, it couldn't constitute written consent, so they didn't go on to consider that broader issue. However, they did say in the future, should the Minister give such a written permission to send an unaccompanied minor to an offshore resettlement country, that such a decision would be reviewable under the Administrative Decisions Judicial Review Act. In practical terms, the majority's decision meant that no unaccompanied child who came to Australia seeking asylum could be removed from Australia unless the minister gave written consent. And the minister is not able to give valid consent unless he could demonstrate he had turned his mind to the best interests of the child. How the court would assess that remains untested, but it's difficult to conceive of many situations in which it would be the best interest of the child to be removed to a third country for the assessment of their claims under the Refugees Convention. After losing this particular case, the government in September 2011 unsuccessfully attempted to amend the Migration Act and the Immigration Guardianship of Children Act. Some months later, in June 2012, another boat carrying asylum seekers, which was just the subject of a coronial inquest here in Perth, foundered off Christmas Island, in which 17 people were confirmed dead, 76 people unaccounted for, presumed drowned, and 110 rescued. The sinking of the boat reignited a debate in Parliament about how best to deal with the issue of boat arrivals. There was a legislative debate, a very passionate debate, but there was a failure to resolve the impasse between the opposition and the government. By way of resolving the deadlock, the Prime Minister announced the establishment of an expert panel to advise on how the government should go forward. The terms of reference of the expert panel were that it was to provide advice and recommendations to the government on policy options available and to provide its considered opinion to prevent asylum seekers risking their lives on dangerous boat journeys to Australia. And it's an interesting terms of reference because the specific aim of the expert panel was about how could we prevent people from coming, rather than perhaps approaching it from a more humanitarian perspective. The three-member panel was to report to the Prime Minister before Parliament sat in August 2012. They only had 6 weeks to deal with a very difficult problem. The panel met and received a number of submissions. It was constituted by and headed by Angus Houston, who was a previous Defence Chief of the Defence Force, Michael Lestrange, who was a former diplomat, and Paris Aristotle, who is a refugee advocate. None of them were lawyers, which I think was a big mistake. In its report released in August, the panel argued that there had to be a stronger regional framework to provide incentives for asylum seekers to apply for asylum in other places rather than take dangerous boat journeys, which we would all agree with. In making its recommendations along those lines, it said we should increase our humanitarian intake from taking people overseas to 20,000 places immediately, with 12,000 places allocated specifically for refugees, which the government acted on. It asked for funding for regional capacity building, that there should be money and funding being given to countries like Malaysia and Indonesia on how to best support refugees and asylum seekers in their country. $10 million was also announced to fund the regional capacity building. And they urged that we continue to work with Indonesia, Malaysia and the source countries of asylum seekers to address the issues. All of those strategies we can't disagree with. They're designed to protect and improve protection for asylum seekers and refugees in our region, such as those who would be found to be refugees, so they could remain safely in their countries on an ongoing basis, or at least be safe while awaiting a determination and resettlement through UNHCR. They also put forward the much vexed no advantage principle. The panel stated that in order to deter people coming to Australia by boat, the regional framework needed to work in order to ensure those who pay people smugglers to attempt to enter Australia by an irregular way would not achieve a faster result than those who pursued regular migration pathways closer to their home countries. The report also set out a range of disincentives, designed, they said, not to punish those who were seeking protection, but to ensure boat arrivals in Australia did not gain an advantage over those who stayed and remained waiting in the region. Key to this was to re-establish regional processing centres in Nauru and Papua New Guinea. The panel said that these were needed. We needed to have a circuit breaker to stem the current flow of arrivals to Australia. Anyone sent to either country would be provided with protection and welfare consistent with Australian, Nauru and Papua New Guinean law and their international responsibilities, including the Refugees Convention. Any processing at regional processing centres had to be commenced according to and have underlying them certain safeguards. They said, we do not want to see a repeat of what occurred on Nauru and Manus Island during the period of the Howard government. So they said there should be treatment consistent with human rights standards, people should be provided with appropriate accommodation, appropriate physical mental health services, access to education, vocational programs, assistance from a lawyer when preparing your protection claim, access to independent review. Neither of those things existed under the previous regime. Monitoring of care and protection arrangements by a representative group drawn from government and civil society in Australia and Nauru and PNG. And that's a group that I'm a part of in terms of being part of civil society and independent representative monitoring the regional processing centre in Nauru. And as Marianne said, I visited in March and I was also actually there last week. It was a very difficult time, and I'm happy to answer questions about that during the question time if you want to. And there also had to be some case management assistance. Unfortunately, at the same time the panel recommended these important safeguards, they said given the decision of the High Court in M70, there needed to be a new legislative arrangement to be passed by the Australian Parliament in order to effect the establishment of regional processes in Nauru and Papua New Guinea. The panel didn't say what those arrangements should be, which is why they needed to have a lawyer. The release of that report was immediately followed by the reintroduction and successful passage of amendments to the Migration Act and the Immigration Guardianship of Children Act. The Act replaces the troublesome Migration Act, Section 198, with provisions that empower the Minister to make a legislative instrument designating a country as a regional processing country if the Minister, quote, thinks that it is in the national interest, unquote, to make a designation. Previous requirements concerning countries' human rights records and capacity have been replaced with a stipulation that the Minister must have regard to whether the country has provided assurances relating to non-refoulement and by the willingness to assess or allow the assessment of refugee claims. But those assurances need not be legally binding, and they have formed part of the Memorandum of Understanding that has been entered into by Papua New Guinea and Nauru. Problematically, the amending Act also pursued the government's agenda to remove the Minister's written consent during the removal or deportation process of unaccompanied minors. In discussing the issue during debates on the proposed law in the Senate, Senator Lundy put forward the government's view. The purpose of the amendment was clear. In effect, she said, the bill before us reasserts the primacy of the Migration Act with regard to unaccompanied minors, and the amendments to the Guardianship Act will also put beyond doubt the Minister's guardianship ceases once a child is removed from Australia or is taken from Australia without a visa or right to return. So are these safeguards in place in Nauru and Papua New Guinea? Clearly, if you've been watching the news, there are certainly a number of gaps. But the removal of the human rights provisions from the Migration Act mean there's little opportunity for courts in Australia to review that question before a person is removed. We now know what's happened in Manus Island and in Nauru. We've seen reports of Amnesty International Australia, the United Nations High Commissioner for Refugees. The conditions are harsh. Processing on Nauru started only in April, but people were moved there in September and lived in tents for several months in very harsh conditions. There's still no decisions from the authorities in Nauru. Processing on Papua New Guinea hasn't even really started. And conditions for children and families that were sent to Manus Island were particularly difficult. So let's go back to Mustafa. What would have happened if he'd come to Australia if his boat hadn't sunk? If he arrived after the 12th of August 2013, with these amendments to the Migration Act, he could have been sent to a regional processing centre. Are there unaccompanied minors on regional processing centres? Well, not at the moment, but possibly if they're not age determined correctly. If somebody looks at you and says they think that you're 18 years of age, or age determines you to be 18, you could be vulnerable to have been sent to a regional processing centre. Those that have been otherwise who aren't sent to a regional processing centre, and unaccompanied minors included, are placed in detention in Australia. This can be for several months. And again, I don't have time to go into the effects of detention, particularly on young people, for a protracted period of time. But to its credit, the government has introduced good community detention arrangements, and many unaccompanied minors are released into the community with care arrangements. But there's a backlog now because of the number of arrivals in processing. If Mustafa had made it to Australia, given he would have arrived in around May this year, he would be waiting for around 4 years, I think, before his case would have been finalised. Perhaps his case could have gone quicker. We could have made an argument because of his young age he'd be able to access protection and processing quicker than others. He wouldn't have been able to leave Australia until he had been found to be a refugee. He could go to school, he could live in the community, but he wouldn't have access to family reunion. His whole purpose in leaving is to provide a better life for his family. Unfortunately, amendments to the migration regulations, again as part of the package of amendments, mean that unaccompanied minors no longer have access to proposing their parents to come to Australia. Again, on the basis that if we allow this to happen, then more children will be sent in order to bring their parents. What if he stayed in Indonesia, which is what he did? If we look at the policy to establish more humanitarian places, that did happen. 1,000 people were resettled from Indonesia, and terrific work was done by both the Department of Immigration and UNHCR to push those numbers through. A similar number came from Pakistan, and these are positive steps in the right direction. Some money was also given to establish better care and protection for unaccompanied minors in Indonesia and Malaysia. However, of those 1,000 people that came from Indonesia to Australia, only 14 were unaccompanied minors. Australia has traditionally not resettled unaccompanied minors from overseas because of the complexity of the legal arrangements once they arrive here. This is the first time they've ever taken unaccompanied minors. It's undoubtedly a step in the right direction, but I'm sad that it was only 14. And they want to now review that particular pilot project before they accept any others. So what incentive is there for someone like Mustafa and other unaccompanied minors to use the regular migration pathway? Policy continues to work to mean that they would continue to try to come by boat. But still, we've seen boats have arrived, even despite some of these positive moves for a regional framework, the establishment of regional processing centres. Over the last year, 23,000 arrivals came by boat, which is a huge increase. Your chances of being sent to a regional processing centre dropped to 1 in 18. So it wasn't the circuit breaker they were hoping for. But the government wanted a more immediate result. So now, while I try and write this talk, that's another change. What happened if he arrived after the 19th of July? The Prime Minister, Kevin Rudd, announced with the Prime Minister of Papua New Guinea that all arrivals, including unaccompanied minors, families, men, will be sent to Papua New Guinea for processing. And if they're found to be refugees, they would never be resettled in Australia. They will be resettled in Papua New Guinea. On Saturday, thanks again, I had to change my talk again, we entered into another agreement with Nauru along similar lines. Agreements have been signed with Papua New Guinea, they've been signed with Nauru, but it's not clear exactly the legality of those agreements and how they sit under the Migration Act. So what happened to Mustafa? After his boat sank, he went to live in Cisarua in Bogor in Indonesia. Some of the others he was with got on another boat and went on to Australia, but he was too scared. We helped him register with the UNHCR. He got some support from the International Organisation for Migration in terms of food. They paid for his room. He had an interview with UNHCR on the 11th of June, which was incredibly quick. Normally they had to wait for 9 to 10 months, and he was found to be a refugee. They moved him to accommodation, the crowded accommodation in Jakarta for unaccompanied minors with others. He told me, "I can't go back to Pakistan. It's not safe there." He still continues to be very worried about the safety of his mother, his sisters and his brother. He says he has trouble sleeping at night. I know, because he's always on Facebook messaging me. And he talks to his mother when he can, and he says that she's always sad and worried. But good news, don't want to depress you, about 2 weeks ago, he received the news that he would be offered resettlement in the United States. He's lucky. He's disappointed. So am I.
Yeah.
He didn't get to come to Australia, but he'll be safe. Sorry. Okay, I just will conclude there because I shouldn't talk anymore. So he is lucky. Unaccompanied minors in the future that come to Australia won't be so lucky. Sir Ronald Wilson, as you talked about before, Marianne, later on in his career as President of the Australian Human Rights and Equal Opportunity Commission, looked at the Bringing Them Home report. In looking at the situation of Aboriginal children who'd been separated from their family, he noted that Indigenous families and communities have endured violations of their rights, gross violations of their human rights, and those violations continue today to affect the lives of Indigenous people. And as you noted, we've recognised today that that was wrong. We've said sorry. We have a sorry day. There's still much to be done. And I hope that we soon recognise the wrongs that we continue to do today to refugees and asylum seekers. Thank you.